So thank you all for being here. I feel like after the conversations we had in the past few days, I'm going to take a slightly different approach and go into a very narrow and legalistic topic. So I hope I will not alienate. Okay, thanks. Emily's happy about it. It's great. But other people may not be. But I think this is important. And this is important for several reasons. I think we mentioned yesterday during the panel, like one of the most important things about EU law and what industry thinks about it is scope. So how do you get out of scope of the regulation? So this is really important because this mechanism that we are going to talk about are the ways in which you are put in scope of certain regulations. And we already see for ones that have been enacted have entered into force in 2022, that case law is starting to shape when the Commission tries to put certain entities in scope. So we've seen it, for example, with the DMA case law now that has been decided by the Court of Justice. So, and this is also how we go from a broad sense of topics to a narrow one, and how we look also at different techniques of regulations and how this can be adapted to technologies as it changes. And I think we will see in the course of this presentation how this affects the technologies that we are regulating, especially when it comes to AI. So, just a background. This is an overview of EU law in the digital space. So if you're a lawyer, this is like a lot of work. So you can see the darker green ones are the ones that are currently in force, and then the other different shades are what are proposed, planned, and so on. So out of all this wonderful set of regulations, we are just going to focus on a few of them. So I have to, there is a disclaimer here. So you might see examples of designation occur in other pieces of EU law, but they are not relevant for what we're going to talk about. And most importantly, a lot of the times they concern how member states have to designate certain authorities to carry out certain tasks. So what we're going to look at is DMA, Digital Markets Regulation, Digital Service Act, and then AI Act. They were enacted in this order. Okay. First of all, we need to think about why the EU legislator has decided to go with this mechanism, starting from the DMA. And of course, as you were probably all familiar with, proportionality is one of the key concerns. We don't want to overregulate, and this was before simplification and a bunch of calls for make things easier for businesses were made, but still, it makes sense to not subject every entity to the same stringent rules based on some objective grounds. And we will look at what those are in the course of this talk. And also, it's a core component of a risk-based approach. But crucially, and this is what I think it's really important that at least you take away, it is how the EU centralizes enforcement. So this is a departure from previous models, notably the GDPR, and it draws from lessons of problems that have come up trying to enforce digital rules. And so the Commission has this goal of becoming a centralized enforcer for certain things based on a proportionality consideration, a risk-based consideration, when it makes sense to do that. And the idea, and this is explicit with the AI Office, of course, is becoming a center of excellence and develop the competency that is probably easier to do at a centralized level at the EU rather than allowing it at the member state level. Okay, so now just a very quick overview on how these mechanisms work in other pieces of legislation. So the first one, we have the Digital Markets Act, and it's pretty straightforward. So an undertaking, which is a term for competition law, just basically designated to qualify the subjects of the regulation, has to meet three conditions to be designated. And this you can see on the screen. It has to have significant market impact, has to provide core platform services, and enjoy an entrenched and durable position. These are all very fuzzy things. There are some criteria in the DMA that establish a presumption for where these three conditions are met. And if you're familiar with the AI Act, this might ring a bell, the mechanism of criteria, presumptions, and so on. On the other hand, we have something that's called always a designation, comes from Digital Service Act, which is to establish when, and this, I'd like to point your attention, this is one of the first time we see a switch from designating the entity to designating what the entity is providing, which is similar to what happens with the AI Act. So in this case, VLOP and VLUs are designated, not the providers of those. And the criteria here is quite straightforward and doesn't admit a rebuttal of the presumption. if your service has an average monthly active recipients more than 45 million, the Commission will tell you that they want it to designate it and then proceed in doing so. And this is not something that can be rebutted. So once you're designated, you are designated. You can challenge it, of course, on normal principles of EU law, but that's about it. You cannot challenge the fact that you don't meet this criteria. Now, we get to the point where designation and general purpose AI model come together, and I'd like to maybe get a sense from you whether you think there might be an issue in using this tool for GPI. And I'm putting here 2 pointers for you to think about. So before you are being addressed a designation decision, you are not in scope of the obligations that, for example, in DMA are for gatekeepers and in DSA are for the very large online search engines and platforms. And then when you are addressed the decision, you have a timeline for compliance. Would this work, in your opinion, when it comes to AI or GPI? I think what we've covered in the past few days is that sometimes the risks that are coming and what providers must do needs to happen at a moment that is before it's placed on the market, for one, and then most importantly, even before the Commission activates and sends a decision and so on, because the risks might be manifesting already at that time. So this clearly is not a mechanism that is fit for GPI. But it is what we have, so it's easier to use something that we already have, right? We don't have to think about much of it, and we can say this was used successfully in other places and so on. Okay, so there you go. Classification. Okay, solved, right? I mean, maybe. Let's see. What is classification under the AI Act and how it is mixed with the designation? Okay, so classification comes from Article 51, which I think you all must have seen. And this is how it works. There are 2 ways to be classified as having high impact capabilities, which means that then you will be considered to be a general purpose AI provider with systemic model with systemic risk, which will then have obligations for the provider of such model. The 2 avenues are it has high impact capabilities, which we know, and there's a presumption there from point 2, and then based on a decision of the Commission, right? So I look at it. This is called classification, Commission decision. So the decision of the Commission will be called it's not called a classification decision, it's called a designation decision. And this, I think, is part of where we start to see some of the issues that might come. So we have a substantive norm claiming that establishes something that's called classification, and then the procedure doesn't talk about classification, talks about designation. However, the intention seems to be to have the effect of a classification. So this is where it comes from. We have the procedure of Article 52.1, which is basically drawn from the DMA, and then we have the special under point 4 of the same provision, which mentioned the scientific panel, but also the possibility of designating ex officio. Now, this is important because it may create some issues when it comes to the effects, the legal effects of this, in the sense that classification seems to operate when the condition is met, when the provider knows that the condition will be met, whereas when it comes to designation, it's probably something that has effect once the provider is notified, and the AI Act doesn't say much in this regard, but it's systematically possible to argue that there must be a time that the provider is allowed to comply once he receives the notification, the designation decision. However, as we said, it might be tricky for a provider who has a model on the market that is not classified, so they didn't do all the things that they were supposed to do for a provider of systemic risk, and then they're classified. It might be challenging to comply with this provision. Okay, so these are a few things that I mentioned, and I would like to point out that now you see the structure is the same as the designation from the DMA, but with the crucial difference that we considered. And it's also important to highlight another point, which is that this is a departure from the ladder approach of the AI Act in general. So we have this risk-based approach, which is supposed to be gradual, and then the classification, on the other hand, occurs with this very discrete threshold that establishes the presumptions. It is true that providers can rebut the presumption, and it is something that I think the Commission is trying to learn a lot of lessons when it comes to how this will work in practice with respect to other examples that are established. But crucially, and this is quite important, this does not matter for the competence of the European Commission to regulate GPI. This is established somewhere else. So I wonder, and this is kind of a provocation, whether we are taking something that existed before and kind of using it in a way that doesn't fully take into account the origin of this legal mechanism. Because the competence of the European Commission on GPI and GPISR is established regardless of the designation. And this is important. So now, this is just for the legal things that are related to the differences between the two and how these things interact and what could happen. But there's also another aspect that is about coordinating all these different provisions. So now you will see the activity of the DMA team and the DSA team has been going on for a while. Their instruments were entered into force in 2022. And so we are starting to see the decisions that have been designating, in one case, undertakings, in the other case, platforms. So we have, this is the DMA. So usual suspects. Also a disclaimer, I removed all the porn sites from the DSA stuff, but it's, just for your awareness, there are some porn providers that are not here because I couldn't find their logos. Then we have DSA, or sometimes I could find it, but I didn't want to include. And then there's the DSA, and you already see there's some overlap here. So there might be some entities that are faced with kind of overlapping requirements from the two, which, to be fair, they deal with different sections, different obligations, and so on. And then we don't know yet, because this has yet to happen, but we can draw maybe a speculative circle, which may be called AI Act classification, that's designation. And yes, so you can see there's, at the intersection of all these three circles, we have some of the providers, and can you maybe spot an issue here, maybe, of all the providers that have been designated? I think ByteDance is like waving a flag from China, but on the other hand, all the other providers seems to be coming from the US, which is something interesting to consider. And this also creates some other issues for providers. I'm not going to go too much into details on this, but I think it's something that if people want to spend some time doing a very cool project, they could look at, for example, what is systemic risk mitigations under the DSA and how does it affect the AI Act systemic risk mitigation, for example, and also looking at for the manipulation that is present in both instruments. This is what it's like referred as 2 times risk assessment. And then, most importantly, there might be a case where multiple enforcement actions are being directed at the same provider for different services. And this might be tricky to coordinate internally from the Commission, but also it might be tricky procedurally when it comes to providers having to defend themselves versus the same entity for maybe things that could be, broadly speaking, conducted under the same types of investigation by the same subject. So I think I'd like to close now, and that's the main takeaways. So these mechanisms were meant to trigger the competency for the European Commission. Unfortunately, or fortunately for general purpose AI model, these mechanisms do not seem effective to make sure that systemic risks are mitigated at the moment in which they should be mitigated. But asterisk, there's still a designation possibility, which is interesting in that sense. And then, ultimately, I think that the effectiveness of this mechanism depends heavily on the European Commission's capacity, internal coordination, political courage to enforce this obligation in a meaningful way. And otherwise, it might be just signals of what's called sometimes in international law as a bark jurisdiction. Yeah. Thank you very much.